And welcome to the Week 15, Chapter 15 video lecture. In this chapter, we're going to be dealing with appellate and habeas corpus review. Essentially, this is the last stage of a criminal justice case, and it must be that the defendant was found guilty before we would get to the appellate court, because once a person is found not guilty, jeopardy is attached, and there is no appeal for the prosecution in criminal cases. Okay, so let's get started and see what we're going to learn in this chapter. First, we're going to explain how the appeals and the appellate process differ from trials and the trial processes. You'll see that it is radically different. In essence, all the appeal court is really looking for is errors of law. They will not get into factual determinations for the most part. The only time they'll ever get into a factual determination is when some fact was found to be true and there was absolutely no evidence to suggest that it was true. That's the only time that they will make a finding that that fact did not exist. But that's essentially an error in how the case was tried. And so that's what they're looking for. They're looking for errors. If there was an error in the trial in a legal sense, they're looking for it, and they'll determine whether it happened or not. And then, of course, once they do that, there's a second question that has to be answered before they would ever reverse the trial, and that is they have to decide that it was not harmless error. That means, yes, there was an error, but it would not have made a difference in the case. That would be considered harmless error. They will not reverse a case and send it back for a new trial. If there is harmless error, that means errors that would not make a difference. So the underlying idea behind all this is that you're entitled to a fair trial, but not a perfect trial. So you could have a fair trial on the issues, even though there may have been one or more errors in the process itself. And by the way, errors can happen, legally speaking, in the admission or exclusion of evidence, in the instruction of the jury on what the law is, and can even be occasionally a few other little odds and ends, such as doing things that would be very, very prejudicial to one side or the other by the court. All right, number two, we're going to describe the two primary functions of the appeals, and then we're going to explain how double jeopardy limits appeals by the prosecution in criminal cases. It limits them, all right, because if there's a finding of not guilty, there will be no other prosecution of that case. There is no appeal. Now, it's possible there can be an appeal by a prosecution in a criminal case, but only if there's a finding of guilt and perhaps the sentencing was incorrect. And then the prosecution can appeal the sentencing, but not once a not guilty happens, it's over with. The prosecution will never be able to appeal that. All right, next we're going to define the contemporaneous objection rule and explain its impact on appeals. What that means is that you must object to something you find to be improper at the trial, and at the time it happens at the trial, not later on. If you don't, you will not be later allowed to object to it. It's essentially considered a waiver of the error. You've essentially waived the error altogether because you did not object to it. And the reason for that is that if you don't object to it early on, the court can't do anything to undo it or to prevent it. If you object in a timely way, then they can prevent problems. And so there's nothing they can do for you. Essentially, if you're going to let it go, you've let it go, so to speak. Also, we're going to differentiate between mandatory and discretionary appellate jurisdiction. And we will see that in pretty much all states, I'm sure it's actually in all states, there was one right of appeal, that's by right, in any criminal or civil case. But that's it. You don't necessarily have any other right to appeal beyond that level. Depending upon what your appellate court is, which in some cases the appellate court is actually the Supreme Court because they don't have an intermediary appeals court process. But they, if you have a right to an appeal, you will go to whatever is your appellate court for the trial court. And next we're going to identify the different appellate standards of review and evaluate their impact on criminal appeals. Then we'll describe the 6 customary phases of the appeals process. So you'll see how we go through this process, how it's actually done, and you'll get a pretty good idea why it takes so long. And then we're going to compare and contrast plain error, reversible error, and harmless error. We talked a little bit about harmless error already. And we'll get into what's plain error and reversible error as different aspects of the word error. Because again, all that the appellate courts are looking for are errors. If there was an error in the trial in some fashion, they want to find it and then they want to evaluate it. Next, we're going to analyze the reasons why most criminal appeals result in convictions being affirmed. We'll see why in a few minutes. All right, we're also going to compare and contrast appeals and post-conviction review processes. And then we're going to identify the leading causes of wrongful convictions. This is based on a number of cases where there have been findings of wrongful convictions. And we got a pretty good idea of what caused the wrongful convictions from those cases. And then we're going to analyze how state courts of last resort and the U.S. Supreme Court exercise their discretion to set justice policy. All right, let's look at the nature of the appellate process. Generally speaking, we're dealing with a three-panel court in the appellate court. We don't use a single judge in an appellate court typically. Some panels are a little bit larger, but not very many smaller than 3. And it has to be an odd number, of course, because we don't want a tie when they vote as to which way the case should go. Essentially, the appellate courts were created because several heads are better than one when examining legal issues. These are important issues. These are where people think they've been wronged in some fashion by the criminal justice process. And so we better take it very seriously. And so we want to have more viewpoints than one to look at it. We're going to look at it very, very closely. We're going to make sure, as much as we can do, that you had a fair trial before there was a finding of guilt, and that you got a fair sentence once you were found guilty. And again, the purposes of the appeal are error correction and policy formulation. So what this means is that we're gonna find errors. We may or may not correct them depending upon whether they are harmless error or not, but we find them, we evaluate them in terms of whether we should send it back for a new trial. And then policy formulation is where we actually create ways in which the criminal justice system will have to operate in the future to make sure that they don't run afoul of the Constitution, the right of fair trial, all these things. They become very important. So those are ways to do it. So, for instance, an appellate court might have, but although did not decide the Miranda versus Arizona case, where they, by policy formulation, decided on the fact that an in-custody defendant or suspect would have to be given the Miranda rights before there can be custodial interrogation, or the statements that are elicited outside of Miranda would not be allowed to be brought into evidence. That's a policy formulation. And again, it could have been done at the appellate courts. It was actually done at the Supreme Court level, of course, as we all know. But the Supreme Court is an appellate court actually, but just the highest of the appellate courts. All right, so let's go into the next slide here very quickly. Let's look at the review of the case of Roe versus Wade. We know about the case. It was the case regarding whether the government can forbid abortions, and many states were doing that, exactly that, and were causing some grief. And so someone decided to bring it up. But I think I have a constitutional right to an abortion. That was what this case was all about. Why did it need to be reviewed? Well, the reason why is because it was a very large issue. And there may also have been another thing that went on, and that was it could have been that some appellate courts said it's unconstitutional to forbid an abortion, and other appellate courts may have said, no, it's not against the Constitution to forbid abortion. So you may have contrary views. And that could happen in different states. It can happen within the same state. And so we need to bring that up to a higher court to get it decided so we know what the law is in those cases for forever and for good, at least as much as we can. And then the next question is what did society gain from this review? Well, they got the issue out and decided on whether there was a right to an abortion that the state could not forbid. And of course, they decided that there was. Do you believe that an issue such as this should have been reviewed by several people or left to its original jurisdiction? Essentially, should it have been decided by the trial court and left where it was, or should it have gone up to the higher courts? Well, again, on the very, very important issues where jurisdictions are looking for guidance as well as for the people who want the case to go their way. It's really important that it be decided at the highest level, because once it is, it'll sort of be pretty much set in cement for a very long time, if not forever. There are many cases that have been the issues have been decided, and we will never see them reversed again. In essence, a court can reverse itself on a constitutional issue, and it has happened before. Whereas a court 50 years ago decided something was unconstitutional, and then 50 years later, a new court decides that it is constitutional. It can happen, and the opposite can also happen. What benefits are there to having several people review this case? Well, you get a better decision-making process. You get more points of view. You get more discussion. If you had one person, you're going to get one person's viewpoint. If you have 9 people on a Supreme Court panel, for instance, you're going to get 9 viewpoints, and we will get the best decision we probably can make. So what policy was put in place by this case review? The policy that was put in place by this is that there can be no prohibiting of abortions by the state except when it's medically necessary to prevent it, and that usually has to do with when they're in the trimester and that sort of thing. But that was what actually happened. The policy that was actually implemented by this was that the government now had to keep their hands off abortions, except perhaps to regulate them to make sure they are done correctly. And Sandra Day O'Connor. Let's discuss cases that Sandra Day O'Connor supported. She had some really good decisions, and you might imagine why based on what the decisions were. She was a very very powerful member of the United States Supreme Court through 2006, and if you look at the cases where she made the difference in the ruling, some of the first ones were she affirmed the right of state colleges and universities to use affirmative action in their admissions policies to increase educational opportunities for minorities and to promote racial diversity on campus. There was just a whole litany of them. In Planned Parenthood versus Casey, she broke with Chief Justice Rehnquist and other opponents of the woman's right to choose as part of a 5-4 majority in affirming Roe versus Wade. Interesting. So she was the reason why that case went the way it was. This is why there's been some thought recently that Roe versus Wade might be overturned on the basis that it was a 5-4 decision. The court now, the makeup of the court is radically different, and it might go towards allowing at least a limited amount of anti-abortion laws. The impact on the cases that she decided was huge. She was often the swing vote on a number of the cases, and so she had a very, very significant career as a United States Supreme Court justice. Who replaced her? That was Justice Samuel Anthony Alito, and he was a George Bush appointee, and he had a conservative background also, but replacing her in terms of doing the same thing that she did, no, and that would never happen. Although it was they had similar ideas, similar viewpoints, and so on, but it's never the same. And the major cases that she reviewed, just look it up, because Google, what is Sandra Day O'Connor known for, and you will get a whole litany of cases where she was a swing vote, and you'll see many of those being very significant decisions for the nation. All right, let's look at the scope of appellate review. What you need to know is the losing party in a lawsuit, whether it's civil or criminal, has one right to appeal to one appellate court, and that's it. There is no other right to an appeal, generally speaking. Now, I will say that sometimes by legislation, for instance, you can have, you can specify what appellate court you'll be going to. Like in California, if it's a death penalty case, you have one right of appeal, but it's to the California Supreme Court rather than to the California appellate courts. That's only true in death penalty cases. And that was to eliminate additional appeals because, the United States Supreme Court or the California Supreme Court would probably take the case anyway. So why not just, have an original appeal there? What happens here is the defendant is no longer considered to be innocent. They were found guilty by a jury of their peers after a presumably fair trial, even though we don't know for sure yet whether it was a fair trial, because that's what we're going to be looking at for the appellate process. Because again, the appeal court's going to look for errors and look to see whether it was harmless error, if there were any errors, and or whether they have to reverse because the errors would have made a difference. Again, no appeal for prosecutors of a finding of not guilty. That's because of the double jeopardy clause. These appeals are often discretionary to higher levels, such as the Supreme Court of each state, or certainly the federal Supreme Court. And this would be true in state courts, except in death penalty cases where they tend to be a right of appeal. And again, typically they'll give you a right to appeal to the Supreme Court. And there can also be interlocutory orders that are made. What are interlocutory orders? Are orders of the trial court, not the appellate court, that are appealed rather than the actual verdict of guilty. So essentially, you can appeal from an order that was made in the trial court before there is an actual verdict. This would be like, say, a prosecutor got a bad ruling on what the law is in a given case. His only way of getting an appeal on that ruling and saving his or her case would be to file an appeal on the interlocutory order of the trial court about what was the law in that case. Again, if the law is incorrect, the appellate court can correct that and order the trial court to do the law right. So that would be the only way a prosecutor could ever appeal a case and save it from a bad ruling. Okay. All right. Let's look at limitations on the right to appellate review. First, there will be mandatory appellate jurisdiction when, of course, everyone has a right to one appellate court, whatever that court may be, whether it's the intermediate appellate courts or the Supreme Court. You have one right to appeal, and if you ask for an appeal, which is why you have to file a piece of paper that actually says you want to appeal your case, that's very easy to do, then it becomes mandatory. And the appellate jurisdiction issue has to do with the fact that the appeal court does not have jurisdiction over the case until there is a notice of appeal filed in the trial court. There's no jurisdiction. The appellate court can't do anything with a case until it is the appeal has been filed. There's also what we call discretionary appellate jurisdiction. So you could have someone who has gone through their right of appeal, lost on that appellate level. More evidence comes up later on indicating that the defendant is actually innocent. And then the appellate court can, through its extraordinary writ process, allow itself to hear a discretionary appeal, so to speak, which really is a writ process, where you file a writ asking the court to do something extraordinary. because there's no legal right to appeal any longer. All right, let's look at the appellate standards of review. There are different amounts of deference that appellate courts will give to the decision of a judge, a jury, or administrative agency, and that is what we call the standards of review. Some standards of review say we will not reverse what a judge says on a certain type of issue, absent a clear case of error, meaning there would have to be something they did really, really wrong before we will do it. There's a lot of things that judges can do. For instance, making a decision on bifurcating a case. That's something that, except in the absence of really good evidence of a clear abuse of discretion, the appellate court will not set aside what a judge does. A judge is there, sees all the issues going on, is in the best position to make that decision. So they will only review it if there's a clear abuse of discretion somehow. It's obvious what they did was totally wrong. Then they'll review it for an error. Now, there's other standards of review that says that the appellate court can simply review the entire issue on their own without even knowing or caring what the trial court did with the decision, because it's entirely their decision. And that would be on the issues of law, what law should have been applied to the case. Standard of review is the law is the law, and we don't care what the trial court did with it. If they did it wrong, we're going to review. We're going to send the case back for a new trial. And so the standard of review can be either a very wide scope sometimes or a very narrow scope, depending upon what issue is being litigated. And it's the appellant, the person who is appealing the case, that sets the issues for the appeal. They essentially complain of error in the trial court, and it's only those complaints that will become at issue in the appellate review. So if an issue does not come up in the appellant's brief that they ascribe an error to, then the appellate court will not review it. Okay. All right. So just know that there are standards of review that have to do with clear abuse of discretion is the only way we'll even review it at all. And there's others that are called de novo, and that means that we will look at it all new, and we have total discretion in the matter. Okay, so it goes from a very narrow scope to a very large or wide scope. Okay, what this really means is that we will almost never see a question of fact being brought up to the appellate court. So you won't say, for instance, the jury found that I did enter the house with intent to steal something inside, and that finding was really not a very good finding. We don't like that finding. If that's what you're going to complain about, the appellate court's going to tell you, I'm sorry, but there was evidence to support it. They made the decision. They were the best people to judge the facts and circumstances of the case. So we are not going to review that factual finding. We are going to accept it as the gospel, again, in the absence of a clear abuse of discretion. And the only way on a factual determination that the appellate court will review it is if there was absolutely no evidence to support their decision on that fact. Okay, so what the jury decides is pretty much within their province. That's kind of scary, but it is true. And the reason why is because the appellate court's not going to give you another trial, and then substitute their decision on whether you were guilty of the crime or not. Now questions of law, now they are given great seriousness on appeal, because that's what the appellate court's looking at. Questions of law are commonly raised on appeal, and they include defects in jury selection, improper admission or exclusion of evidence, and mistaken interpretations of the law. So those are things that we will look at very seriously on appeal, but the factual determinations, it's very rare you'll see a factual determination set aside. And if it's set aside, they will not try the case themselves in the appellate court. They will send it back for another trial. All right. The appellant can also claim constitutional violations, including illegal search and seizures, where there should have been exclusions of evidence. And some defendants have pled guilty, who have pled guilty, may seek to set aside the guilty plea because of ineffective assistance of counsel that maybe was denied in the trial court, but they appeal that denial in the appellate court, and it may be set aside, and they are allowed to go back to trial based on the fact that they did have ineffective assistance of counsel. And that would be a constitutional argument. All right, let's look at the standard of appellate review in criminal cases. Again, we talked about from least to most deferential questions of law. Those are actually not least. These are the most. The least deferential is to questions of law. That's correct. In essence, we give very little deference to what the trial court says about the law. The law is the law. We make up our decision as an appellate court as to what the law is. We really don't care what the trial court did. So that's the least amount of deference given to the trial court. As we go along, mixed questions of law and fact would be given a little bit of deference to the trial court because there's a factual determination involved, such as a hearing on a search and seizure issue. If a judge found a certain fact to be true and based his or her decision on whether to exclude evidence based on a claim of illegal searching, based on that fact, then we're going to probably give them pretty good deference on the fact. We won't give them any deference on the law, but we'll give them deference on the facts that they found to be true. Questions of facts decided by a judge are next most deferential. The questions of fact decided by a jury are even more deferential. And discretionary decisions by a judge on procedural matters are very deferential. Except in the absence of clear evidence of an abuse of discretion, we will not set those aside. All right, there's the standard of review for questions of law are de novo. That means we look at the entire issue of the law that was applied in the case, all new, as if it was brought up to us in the appellate court for the first time. The level of deference to the trial court decision is 0. We don't care what they had to say. The test is there's a plenary review of a legal issue for a second time with no deference to the prior decision. Example, whether a judge erred in interpreting a statute and applying it to the jury instructions, and whether hearsay evidence was properly admitted or excluded. That has to do with what the law is. Those are both total legal questions, and so no deference to the trial court on those. Mixed questions of law and fact. There's a mixture of de novo and clear error standards of review. Level of deference is moderate. The test is underlying factual findings are given substantial deference, reviewed for clear error only. And clear error would require that there was no support for the factual finding that was made. But the legal consequences of those facts are reviewed de novo, because again, it's a matter of the law. If the law is the law and we don't let trial court's decision on what the law is influences on what it actually is. An example, whether a suspect was subjected to custodial interrogation. That's a mixture of factual determination as to what actually happened, and then a determination of the law as to what constitutes custodial interrogation. So it's two things that are going to be going on here. So whatever factual findings there were, there's great deference. But as to how the law was applied, that is a de novo review. Whether a defendant knowingly, intelligent, and voluntarily waived a constitutional right, again, the same thing. We've got to know what happened first to know whether they knowingly, intelligent, and voluntarily waived a constitutional right. And then we have to make a determination based on what the law requires for that waiver in order to make the decision. So it's a two-part test. Now, questions of fact that are decided by a judge. The standard of review is clear error, in essence, a clear abuse of discretion in finding the fact. High level of deference. The trial court's factual findings are to be upheld unless they are so clearly erroneous that they have no support in the record. So if a trial court finds a certain fact happened and there is any support in the record for that factual finding, they will be upheld. Okay, because we're not going to substitute our judgment on the facts for that of the judge in the trial. Examples are whether a criminal defendant is competent to stand trial. That's also based entirely on facts, really. What evidence do you have? And what if there's controversial evidence, which evidence did you decide to believe? And then next was whether a criminal defendant is guilty beyond a reasonable doubt in a bench trial, which, by the way, you don't necessarily have to have a jury in a criminal trial. If both sides waive the right to a jury, then you can have a bench trial. It means a trial before the judge, where the judge will make up the decision as to whether there was guilt beyond a reasonable doubt. And so when a judge decides there was guilt beyond a reasonable doubt, that's a clear error standard. There would have to be no evidence whatsoever to support that in order for the case to be reversed. All right, let's look at questions of fact decided by a jury. The standard of review is reasonableness and whether there's substantial evidence. Level of deference is very high. The test is the jury's decision is upheld if it is reasonable in light of the evidence in the record and there is support for the jury's conclusion. If there is, then we're not going to set aside their factual findings about what happened. Example is whether a criminal defendant is guilty beyond a reasonable doubt. So again, if there's lots of evidence in there and they decide he's guilty beyond a reasonable doubt, sorry, that's done. So your only way of getting out of that decision would be to find some legal error that would have made a difference in the case. And so they were applying the wrong law, but not for what factual findings they make. And whether a defendant was proven in terms of his sanity by clear and convincing evidence, that's another standard by which we will give great deference to the jury's determination. If there's substantial evidence behind it, we're going to uphold their standard. All right, let's look at discretionary decisions by a judge. We use the standard review of abuse of discretion. There has to be a clear abuse of discretion, but the level of deference is very high. The test is that the trial court's decision will be upheld unless it was arbitrary, capricious, or manifestly unfair in light of the reasonable justifications under the circumstances. This usually has to do with procedural matters, like if you want to bifurcate the trial on one count. We'll do one count on this case because maybe you put 2 or 3 cases together. This happens sometimes. And so you may want to try one of them first and see what the verdict is. Then you want to try the next one. All within the same jury panel, but one at a time. In essence, you take one case at a time. The decision of a judge to do it that way is going to be upheld unless it was arbitrary, capricious, or manifestly unfair. Not really. That wouldn't necessarily be unfair. I don't see any reason why it would. You take one case at a time. Why does that make any difference? You would wonder why. So whether a judge abused his or her discretion when denying a continuance, or limiting the scope of cross-examination, or refusing to dismiss a juror for cause would be examples of where it has to be a clear abuse of discretion before we're going to reverse on that basis. All right, let's look at the appellate procedure. How do you actually make an appeal happen? First, you have to file a notice of appeal. It's a written piece of paper that says, I hereby appeal the decision of this court in entering judgment of a verdict of guilty against me in the case number such and such. Okay, done. Once you file that piece of paper, it depends on, by the way, on what the statutes are in terms of how long you have to file that notice. In California, it's 60 days. In other cases, it might be 10 days or 30 days. But very typically, in a case where a defendant is found to be guilty, the last thing for the trial court defense attorney is to file the notice of appeal just to make sure that they don't blow that time period for the defendant and lose their right of appeal. But it happens to be that because of the statute that requires the notice be filed within so many days, if it is not filed pretty much for any reason, except for a fraudulent reason, where someone was defrauded into not filing it, for instance, you lose the right of appeal, even if it's your attorney that didn't file it on time. You will not have a right to an appeal. You lost it. And the appellate court has no jurisdiction by law to hear your case. Okay, so also it's possible, even without the right of appeal, you can file a petition for a writ of certiorari, which is a writ to ask the court to review it under its extraordinary powers to do justice under circumstances where only by reviewing the case could justice be done. Kind of an idea. A writ of certiorari is again another Latin term, but it basically means that you file an extraordinary petition and you ask them for permission to have the case heard. If there are good and substantial reasons behind it, they will, but otherwise they will not. All right, so once you file the notice of appeal, it's been timely filed, the next thing you're going to do is you're going to put together the appellate court record. That's the record of what happened in the trial court, and it's going to be bundled up literally and sent to the appellate court. So what's going to happen is transcripts of the entire trial will be prepared by the transcriber, and all the underlying filings in the trial court will be bundled up by the clerk and sent to the appellate court. So now you have the record of everything that happened in the trial court. It's now in the appellate court. And so you can use that record as a basis for what you're going to be doing in the appellate court, because that's, in essence, you're reviewing what happened in the trial court, so you've got to get all the information from the trial court into the appellate court record. Okay? Next stage in the court procedure is that there'll be a filing of appellate briefs. First, of course, the appellant themselves, that's the party that's appealing, will file their opening brief. And they will make written arguments on certain complaints about what the trial court did that were errors. And they will subscribe every error that they can think of that is something they can support by good argument. And those will become the issues to be decided by the appellate court. So if for some reason one of those issues was not brought up in the appellate brief, it will not be decided by the appellate court. You've waived it. Okay, so you not only have to object to things that you don't think are going right in the trial court to preserve your right to appeal on that issue, you have to bring them up in your appellate opening brief, or you will have waived them that way too. All right, and what will happen is once there's an opening brief, then there will be a respondent's brief. The respondent is the person who's responding to the appeal and defending against it. That will usually be the opposite party in the case. Then there will be one reply brief by the appellant, and then your briefs are done. Next will be oral argument. That's a face-to-face contact with the judges and the lawyers where they get a chance to actually talk to the judges about the case and make their arguments there orally. And then once that goes on, then the appellate court will deliberate, and they will come up with a written opinion that summarizes the facts of the case and discusses the legal issues that were raised on appeal. There will be an opinion that decides the case. Either they're going to affirm it, they're going to reverse the case, or affirm parts of it and reverse other parts of it, as the case may be. Whatever they reverse will have to go back to the trial court for a new trial on that issue or issues. There can be dissenting opinions because we have 3 justices and a 3-justice appellate panel. One of them may dissent, and the 2 others will, at least 2 of them will go with one decision, and then one of them could dissent from it. And the dissenting opinion, if there is one, and there's not always a dissenting opinion issued, but if there were, they will explain why they believe their fellow justices are wrong in their conclusions. And then you will typically have a majority opinion, which is, summarizes why the case is going the way it is, and that's the one that controls what actually happens. Now, you can also have what are called concurring opinions, and those are opinions where the judge that is issuing a concurring opinion will say, yes, I agree with the result of the majority, but I don't agree to their reasons. And so they'll put in different reasons for coming to the same result. And there can also be what's called a plurality opinion. That's has a limited or maybe no precedential value because there's no majority decision. It would be sort of like a 4-4 split in a 9-justice court with one justice, perhaps abstaining, and then so you have a tie, more or less. But there might be a concurring opinion in the result of 4 of the justices. So you would have 4 justices, maybe 1 concurring in the result, and so there's really no majority decision. And then you would end up with a plurality decision. In essence, no majority of justices thought the case should be of a specific result and and for specific reasons. Okay, let's look at the procedure as we go about. You have the opinions, then you have a disposition. So it's either affirmed, it's modified, it's reversed and remanded for trial. It can simply be remanded to have proceedings consistent with the opinion. It can be reversed for plain error or reverse error, or it can be, it will not be reversed for harmless error, by the way. The only way you'll get a reversal of the case is for reversible error or plain error. With the rising caseloads, we like to expedite these appeals because they're obviously, since there's a right of appeal, every defendant that goes to trial will be appealing the case as a practical matter, certainly for any felony. And so there's lots of stuff going on, lots of caseload for appellate courts, and there are much fewer appellate courts than there are trial courts. All right, let's look at the law on the books with regard to criminal appeals. Law on the books, it's an expanded opportunity to appeal criminal convictions. Economically impoverished defendants cannot be barred from effective appellate review. So the state has to pay for the transcripts of the trial, has to pay for an attorney to prosecute the appeal. And of course, usually the Attorney General's office is the one that opposes the appeal. So there's lots of resources involved. The law and action approach, defendants rarely win on appeal. It's atypical of crimes prosecuted in trial courts. It's routine, seldom raise meritorious issues. Again, because if you were a criminal law defense attorney and you have a felony defendant who went to trial and lost, guaranteed you're going to file a notice of appeal for them because you do not want to be hit with a malpractice suit because he later decides that he or she later decides that they wanted to have an appeal and couldn't have it. So you'll just file it anyway, even if there were no meritorious issues that you couldn't see. And it's very rare that we'll get reversible error. Very rare. It happens, but it's very rare. Generally with the scope of review, which is not always de novo, it's sometimes clear abuse of discretion, there aren't many errors. And whenever errors are found, we have to ask ourselves, once we see an error, whether it would have made a difference in the case. And if it would not have made a difference in the case, then you're not going to get a reversal. It's harmless error. Even if it's an error of law, it will be found to be harmless error. You would have been convicted anyway, and boom, you're done. You've lost your appeal. Now you had one right of appeal. Essentially, the case is over at that point. Now, defendants convicted or nonviolent offenses versus defendants convicted of violent offenses, the difference can be big. What this means is that those convicted of nonviolent offenses would probably stand a better chance of having an error found to be a reversible error than those who were convicted of violent offenses. And the reason for that just makes sense. Violent offenses are ones that appellate courts don't want to reverse unless they absolutely have to. These are people who, had their time in court, and if they had basically a fair trial, we're going to go ahead and affirm the decision. All right, let's look at the distribution of types of criminal appeals in the federal appellate courts. This is the federal appellate courts, not the state courts. If we look at the types of cases, drug offenses are 39%, firearms against explosives are 15%. Remember, of course, that federal appellate courts are hearing only federal cases, and so they differ dramatically from what are in state cases. State cases, there's lots of murders, rapes, robberies, all the big things that are there. That's not very true in federal courts because although there are homicide statutes in the federal courts, they don't try a lot of homicides. The ATF will be involved in firearms and explosives. There's certain property crimes that go across state borders. There's immigration offenses. There's sex crimes, but not as many as in the state. And so we'll see that these percentages seem to be lacking the big 12 of crimes. The reason why is because this is a federal court distribution, not a state court. All right, post-conviction review. First thing we want to talk about are these collateral attacks that go on. After the appellate process has been exhausted, the person has been found guilty, case has been affirmed, whether it's federal court or state court, there are often things that happen collaterally against the government. And these are typically, they're filed by prisoners who've been already convicted, gone through their appellate process and lost. And they're typically civil matters, but they're filed against the prison warden, the chief administrator of the state's Department of Corrections, for any of a number of things: cruel and unusual punishment, negligence, failure to, failure of them to protect certain constitutional rights, whatever it may be. These challenges come up all the time, so you'll see this going on. And it's not too infrequent that this is another review that has to be made by appellate courts based on these collateral attacks that are typically civil in nature. They may be filed only by those in custody and may only raise constitutional defects, but they're much broader than appeals. One of the reviews that can come up is another extraordinary writ process called habeas corpus. And what that simply means in Latin is deliver over the body. And that's what it means here too, is that it's an extraordinary writ that you file. It simply says, please order the Department of Corrections to release me because something very, very bad has happened. And in the 1950s and 1960s, U.S. Supreme Court greatly expanded the application of habeas corpus as a way of reviewing cases that where all the appellate stuff has already been exhausted and has been affirmed. Sometimes there's findings of new evidence, and this opened a floodgate of new reviews of cases throughout state and federal jurisdictions. Then Congress greatly restricted habeas access in 1966 as a result, and so it's more limited than it was then. But you can still do it. It is probably the most common of the extraordinary writs that are filed. This is so-called the Great Writ, but essentially it gives the court, it's a discretionary writ. By the discretionary, it means the appellate court does not have to buy into this writ petition and issue this writ. You're just asking the court to do so, and it may say no. I'm not even gonna entertain the writ, the petition for the writ. I'll entertain the petition, but I will not issue the writ. And then it'll give you a summary opinion. You didn't give me enough evidence, whatever it may be. But on the other hand, if there is good substantial evidence that a person did not commit the crime after the appellate process is long gone, they can issue a writ that will order the Department of Corrections to deliver up the body of that person and free them, and probably pending a new trial. All right, how post-conviction remedies differ from appeals. Of course, we have the collateral attacks that go on. We talked about that before. May be filed only by those who are in prison. May raise only constitutional defects and not technical ones. In essence, you can't say, oh, there was a technical issue that should have been done better and it wasn't. This is only for a denial of constitutional rights kind of thing. And maybe somewhat broader than appeals, can bring up issues not raised at the trial, can assert constitutional protections raised since trial, can contest conditions of confinement, and it's unlimited in number. So the only thing that prevents this from clogging up the system is that the appellate courts can simply not entertain it and let it go. They can read it and say, okay, no, denied that easily without even having a hearing. And that makes it a little easier to deal with. It's because it's discretionary. They don't have to hear it. But you can bring up a lot more issues in it. The reason why they have to allow you to bring up things that you did not raise at trial is because you may not have raised it at trial because you didn't know they existed. But maybe there's some new exonerating evidence that came to your attention later on. All right, judicial expansion and contraction of habeas corpus access for state prisoners. That has been sort of an ongoing thing. In the 1950s and 1960s, the U.S. Supreme Court greatly expanded that habeas corpus, as we talked about before. Then Congress came in 1966 and limited it. That's been found to be constitutional. The limitation has been found to be constitutional. And so you have to have certain things to even file the petition now, or you don't even get the petition heard. They won't even look at it until certain very, very strict provisions have been complied with. All right, let's look at a close-up of House versus Bell. This is a federal court scrutiny of death row inmates. Carolyn Mousy disappeared and her body was found in the woods the next day. House, who was a convicted sex offender, was arrested for the crime. There was circumstantial evidence for the defense suggesting that he did not do it. As you might imagine, after he was convicted, placed on death row, then DNA evidence came in that showed that he was not the perpetrator of the act, at least unlikely, because the DNA on the scene in or around the body was from somebody else. And that was pretty good evidence he didn't do the crime. It doesn't necessarily mean he wasn't at the scene and maybe involved in it some other way, but he was not actually involved in the criminal act of rape, for instance. So he was probably innocent, most likely innocent. The Supreme Court dealt with the post-conviction appeals based on DNA testing. It had not yet been done at that time, and that was the first one. So they actually were able to use DNA as a basis for filing a writ of habeas corpus, getting the person released, and then the case went on from there, whatever may have happened. They may have simply reversed and remanded for a new trial, or reversed and let him go. It's possible either way. All right, courts, controversy, and administration. First question I want to ask is, should federal courthouse doors be closed to state prisoners? Should we not allow state prisoners to go into federal courts to hear a second run of appeals? Well, the problem is that we have a United States Constitution that is binding on the states. So why are we letting the states decide the federal constitutional issues? On the other side of the coin, why are we letting a criminal defendant have a second run at the appeals by going through the federal courthouse, as they do so often in death penalty cases? Why do we do that? Well, it's not very efficient. And is it likely to find out anything different happened from the same record? Probably not. So there's some real controversy over this issue. Should federal courthouse doors be reopened to state prisoners, particularly those on death row, to ensure justice is not short-circuited? Or should the federal courthouse doors remain as they are now, with only one federal review, unless the case presents an extraordinary issue? Where should the line be drawn between interests of justice and ensuring that only truly guilty people are executed, and the need for finality? Many of the habeas petitions will raise issues that were very unlikely to succeed. What do we do? It's kind of a difficult question. All right, so habeas corpus for federal prisoners, they may seek this relief if, number one, the sentence imposed violates Constitution or state laws. Number two, the court was without jurisdiction to impose the sentence. The sentence imposed was excess to the maximum allowed, or the sentence is otherwise subject to collateral attack in some fashion. So if you have a sentencing issue, habeas can be used as a basis for setting aside the sentencing. Wrongful convictions, which is something that's just really confounding to the system, to say the least. We have a beyond a reasonable doubt standard. We have all this plea bargaining going on, and so on. So far, DNA exonerations are over 349 inmates since 1989. In California, for instance, any defendant who wants to have DNA analysis of the evidence in their case in a sex case is allowed to do so, even after they've been convicted and sent to prison. Other exonerations, 149 in 2016 alone. So why do wrongful convictions occur? Well, probably one of the biggest reasons is mistaken eyewitness identification. And we talked earlier about direct evidence versus circumstantial evidence. Direct evidence is eyewitness identification. I saw the person do the crime. The only problem with that is if you're mistaken as to the identity, you got the wrong guy, you're going to get somebody convicted of something that they didn't do. And this does happen. Even in lineups and all the things we use to try and prevent it, it will still happen. Improper forensic science. And they used the wrong kind of science. It didn't bring out truthful results. Next is false confessions. Now, false confessions can happen in two different ways. One, someone could be tortured into a confession and give a false confession. And sometimes false confessions are done voluntarily, often to save somebody else, someone close to the person who does the false confession. I don't know how we can save someone from a false confession if it's voluntary. We certainly can save them from an involuntary false confession, but not one that they do by themselves. The only way that we could maybe hope to see that a confession is false when it's voluntary is for there to be no circumstantial evidence that suggests that they did the crime, in which case they won't be prosecuted. Because if there's not evidence to suggest that they did the crime circumstantially, in addition to the confession, you really can't prosecute them, and you shouldn't. There can sometimes be unreliable informants are giving information, and you go and find that information, but maybe the informants actually placed the information where they said it would be, that kind of thing. There's also tunnel vision and misconduct by justice professionals. It's not unusual, or at least not unheard of, to find a prosecutor, sometimes 20 years after they did the case, they're found to have been guilty of misconduct by holding back exonerating evidence from the defense. This happens. When that happens, that attorney is usually disbarred and possibly, and more likely, also subjected to civil liability for the wrongful conviction. Inadequate defense representation is another one, less likely, but it is there. Sometimes they just make big mistakes that deny the person the right to effective assistance of counsel. All right, how do we reduce wrongful convictions? Some policy recommendations include exclude or limit the use of unreliable forensic techniques. Get the courts more involved in holding the line on forensic techniques to make sure that they're generally accepted in the scientific community before we can use them. Then we will do away with some of the more unreliable forensic techniques. You can't just make up a technique and go in and testify to it anymore. You shouldn't be able to. And we want to admit expert testimony on reliability of eyewitness identifications more often, because we can tell you that experts will tell you how wrong eyewitnesses can be and what the reasons are for them being wrong. And they will tell you that the person really does believe that that's the person who did it, even if they are wrong. We want to discipline attorneys who engage in misconduct, most certainly, both defense and prosecution. We want to exclude uncorroborated jailhouse informant testimony. Jailhouse informants are, there's always someone in the jail who's looking for a way to get out. And so they're listening to everything you have to say. They're questioning all sorts of things you have. Well, what are you in for? And that kind of. And so you get these people who will get these statements from people, and they'll sometimes brag about the crimes they committed to the jailhouse informant. Jailhouse informant will go to the corrections officer and tell them they've got a confession from one of these guys, if that's all you've got is an uncorroborated jailhouse informant, they should be excluded, absolutely excluded. The only way we'll let in the uncorroborated jailhouse informant testimony as to whatever the person said when they were in jail is if if there's something that we find that makes it so that we know that it must have happened. So to give you an example, we had a case where there was a murder of a woman associated with this man who ended up killing her. We never found the body. We knew she was dead because she had a child. There's no reason why she would ever fail to come home for the child. We know he had killed her. The kid even talked about the fact that mommy and daddy went in the room and they were arguing, and daddy came out, mommy didn't come out, that kind of stuff. So we sort of knew it was him. He was then in jail, going up on what was then a second-degree murder, because we didn't know exactly how the murder took place. It could have been done some sort of it could have been a non-premeditated murder. Could have been done in the passion type of situation. In any event, the jailhouse informant was talking to this defendant in the jail, and not only did he confess to killing her, he told the jailhouse informant exactly what he did with the body. Well, he burned the body, he said, and he took whatever bones were left, and he scattered them in a certain lake, in a certain place in a certain lake. Well, when we got that information, of course, police went out and looked at that very specific spot at that lake and found bones, human bones. Took the bones, it did a DNA analysis, and it was her. Okay, that's how we essentially corroborate a jailhouse informant. That jailhouse informant had been in jail since well before the murder ever happened. So it would be impossible for that jailhouse informant to have known where that body was located, except by talking to the person who murdered her. Okay, that's a good example. All right, you want to also increase the awareness of how causes of wrongful conviction interact. There can be many different ways that all these causes will interact together. And so we need to be aware of those and do our best to prevent those as well. All right, state courts of last resort, law in the books. State high courts and discretionary dockets. Some states have no intermediate courts of appeal. 40 states in the District of Columbia have intermediate courts of appeal, freeing the state Supreme Court to deal with policy questions rather than have to deal with the day-to-day appeal caseload. Let's look at local appeals. Let's think about some current cases within your hometown. What subject areas do they cover to be appealed, if you actually have some from your own hometown? What cases do you believe speak for society? And do you believe in the appellate process? If not, why not? And if so, to what extent? In essence, do you think it's all right or a good idea that we have at least one right of appeal? Should we have more than one right of appeal? Should we have no right of appeal? Or a very limited right of appeal? Maybe only on certain types of issues. These are questions for you to think about. But the issue becomes now more significant to you if you'll go out and look to see what kind of cases are being appealed in your particular location. Let's look at state Supreme Courts. State Supreme Courts tend to be policymakers. Again, 40 states have high courts that already have an intermediate appellate court system to take up the caseload of criminal appeals. And so these state high courts can be policymakers. That means they take cases only when there's good, substantial reasons to make a decision on that case to set policy for the state. That's both in civil and criminal cases. They will apply U.S. Supreme Court decisions to make their decisions. They will interpret both state constitutional provisions as well as federal constitutional provisions through the decisions of the U.S. Supreme Court. There's a new judicial federalism that we need to talk about. This refers to the movement in the state court or state Supreme Courts to reinvigorate state constitutions as sources of individual rights over and above the rights granted by the federal Constitution. So what's happening here is we're getting into state constitutional provisions. There's no reason why a state, for instance, can't have more limitations on government, more rights to the individual than is in the federal Constitution. And so there's a new judicial federalism going on now, where there are more decisions being made based on the state constitutions rather than the federal Constitution. Law and controversy point of view, state high courts and the death penalty cases. There are pronounced differences in handling death penalty cases from state to state. States with competitive judicial elections are more likely to uphold death sentences, as you might imagine. The federal court system uses judges of lifetime tenure. They can basically not care
it's too much about what other people think about their decisions. That's not true in the states. Almost every state has competitive judicial elections, and so to not uphold the death penalty is to give the media an opportunity to come in and jam you for not being tough on crime, even if it's the right thing to do. Okay. U.S. Supreme Court and criminal justice policy. There was the warrant court. That was the big one in the 1950s and 1960s. Had major developments in civil liberties. It was the Miranda versus Arizona case. Many search and seizure issues were brought out for the first time. And there was the Burger Court in the late 60s all the way through the mid 80s. It was more conservative, but only modest reaction to the warrant court. Then there was the Rehnquist Court in 1986 through 2005. Very pragmatic, but conservative. Then there's the Roberts Court 2005, now more conservative, and it's becoming more and more conservative as we're going along. All right, let's look at the Supreme Court in broad perspective. The decisions of the U.S. Supreme Court swing back and forth, much like a pendulum, but that was part of our system. It is also based, we know that the Supreme Court is based on political appointments, and so we can stack courts with more conservative or more liberal judges, depending on who's in power as the president and the Senate, who will be responsible for actually getting those people into positions in the United States Supreme Court. These swings reflect major political movements in the nation, and so it acts sort of like a pendulum, but it's a pendulum with some weight to it. So it takes a while before it starts to move, but when it starts to move, watch out because it's hard to stop. And it'll go usually pretty far before it'll stop the other direction and start slowly going back the other direction. Public opinion affects justices' lives and may serve to curb them when they threaten to go too far or too fast in their rulings. Yes, they do worry about what the public thinks, and the reason why is because they want to do the right thing by the public. They may not be worried about it in terms of losing their job because they're lifetime tenure, but they do worry about what they're doing and whether they're doing the right thing. So public opinion does make some difference to that for that reason. They want to do the right thing, not because they're worried about their jobs. All right, that's it for chapter 15. And again, if you have any issues regarding the learning for this chapter, please feel free to email or call me, and I'd be more than glad to help.